Thank you for joining me, Dennis. Go ahead and let's talk about what we're intending to do in this conversation. My understanding of this conversation is you want to know about the American states and the laws that they've been passing to shut down the gender abattoirs.
Yes,
And and I had asked you about all of the changing landscape of employment discrimination law in the UK.
yes, yes. I mean, you've summed it up perfectly there, sir. That's exactly why I'm here.
So thank you again for joining us. And can you
Not at all.
just introduce yourself to the American audience who might not be as familiar with you as the UK audience is?
Sure. My name is Dennis Noel Kavanagh. I'm a director of a not-for-profit group called the Gay Men's Network. It's a pressure group that represents gay male interests. By training, I'm a criminal barrister with about 20 years at the criminal bar. I now do all sorts of other things outside of that. So I'm a lawyer by training and sort of rather reluctant gay rights activist by force of circumstance. Didn't really see doing that in my late 40s, but here I am. That's life.
That sounds a very familiar
Mm,
kind of feeling. I
mm.
was a Democratic outside operative, and I was working for a long time in the blogosphere back when that was a thing. And the sort of gender topic loomed in front of me, and I tried to get this, Dennis. I decided to change careers and go into academia for a minute.
Dear God.
Uh, and that's where I discovered that actually I have to fight this. I have to win this fight if I ever want to do anything else with my life.
Yeah.
So I am now an historian, and I am a writer from way back, and that's just my story.
Okay, good. Well, that makes sense, doesn't it? Because it sort of came from academia. So, it's almost like sort of meeting the beast in its lair somewhat. So I can see the logic of going back there.
There is that scene in the hero's tale where the hero has left behind the world in an attempt to get away from the war, and the hero encounters the enemy out in the world trying to get away from the war, and he has to turn around and return to the world with his newfound wisdom in order to win the war. That's what it felt like to me.
That's rather noble. I like that. To me, it just feels like chaos, day in, day out. Every day is weirder than the last, frankly. Such
Yes,
is life.
it's such a strange time to live in.
It is.
And let's go ahead and talk about these strange times.
Yes.
You are over there and you've been tracking everything since the Forstater case.
Yeah.
And that, as I understand it, that case has reshaped the landscape of employment discrimination law. And then we had this case with Joe Phoenix that recently was decided and was quite decisive, I should say, in legal terms.
Yeah.
Um, Legal opinions, as you know better than I do, legal opinions can be very nuanced and frustrating, but that's not what we got in this case. So, can you just talk for a minute about how that landscape has developed?
Well, it developed fundamentally from the decision of the Employment Appeal Tribunal in the case of Maya Forstater. So this was an appeal from the first instance decision. Remember, Maya lost at first instance. And that appellate authority has reshaped the landscape and the debate in gender. Maya was a contractor for a think tank called GCD. She wasn't sacked, but they failed to renew her contract, which is actionable in English and Welsh employment law. She pleaded a case based on our Equality Act. Our Equality Act has a number of protected characteristics, one of which is religion and belief, rather unhelpfully conflated, but there we are. That's the drafting. So she pops along to the employment tribunal. At first instance, she says they were wrong to fail to renew my contract on the basis of my gender critical beliefs. And she fails at first instance because the judge applies a test called the Granger test, which I won't bore you with, other than to say Granger says that in order for something to be a protected belief under the Act, there's got to be a body of support for it. It's got to be relatively popular. It can't be wacko. It can't be something like Nazism or something really really out there and socially sort of undesirable. But the final test in Granger is what's called WORIADS. And that's an acronym, and it stands for Worthy of Respect in a Democratic Society. The first instance judge said, no, this isn't worthy of respect in a democratic society. We were all rather surprised by that. We thought the game was up. We thought that was the end of it, because it was quite an interesting point of politically at that point. The government were going to bring in all sorts of gender identity type things, but we were very lucky in the United Kingdom. Brexit gridlocked the House of Commons so that nothing could get passed at all. And Maya appealed. She appealed to Mr. Justice Chowdhury, sitting in the Employment Appeal Tribunal, and he reversed the first instance judge. He said that believing that biological sex is important, that it is immutable, and the rest of it, just not believing in gender souls, one might think. Mr. Justice Chowdhury said that meets WORIADS. It is, in fact, worthy of respect in a democratic society. And the important thing in that appeal, it's a nuance that's often forgotten, was that Stonewall applied to intervene. Stonewall are our version of, I suppose ACLU for American listeners, or ACON for Australian listeners. And they were refused permission, and they weren't very happy about it. And our own regulator for human rights, the Equality and Human Rights Commission, intervened in that case, and they intervened in Maya's favor. That was decisive, absolutely decisive. Chowdhury finds in her favor. Gender critical beliefs are worthy of respect in a democratic society. And the die was rather cast by that case. Since the Forstater case, I am not aware of someone pleading gender critical views, and you've mentioned Phoenix. There are plenty of other cases such as that, and losing. We simply haven't had one. Forstater has not been overruled. I don't think it will ever be. It's a very, very solid decision, and it's fundamentally altered the landscape in the United Kingdom. It's taking, like all cases, it takes a little bit of time to bed in. People are still treating some of their employees appallingly. But if you want to know the story of how rights, and we call these employment rights, and they do center on employment because it's about people losing jobs, but they've lost jobs principally because of their exercise of free speech, predominantly on social media. That's where, generally speaking, this has been about. So they're not just employment cases; they sort of overlap somewhat, don't they, into human rights. What you would call First Amendment stuff, what we would call Article sort of 9, 10, 11A. So yeah, that I hope is a useful starter. That's Forstater in a nutshell for you.
That's excellent. Thank you. And can you tell us about the Joe Phoenix case? Can you speak to that? Because it was, as I understand it, another decisive decision.
Oh, absolutely. Yeah, Phoenix is a remarkable case. Phoenix is some way down the line, because the next case after Forstater is Alison Bailey, who takes Stonewall themselves and her chambers to a tribunal. And I'll just briefly mention that she wins against her chambers because Stonewall basically tell her chambers to fire her, for want of a better word. I mean, technically she's self-employed, so it would have been firing, but let's not get hung up on the nuance. They basically said, get rid of her. Alison Bailey is a very popular black lesbian at the criminal bar in London. I used to prosecute her back in the day. And she wins convincingly against her chambers. She is currently awaiting an appeal against Stonewall, and that'll be the next big case to watch. So there's plenty of other cases, but coming to your question, which I should do really, case of Phoenix is extraordinary. It's Professor Joe Phoenix takes on the Open University. Now, by the time of the events in Phoenix, the debate has moved on from Maya's case, and Joe Phoenix tries to set up a gender critical staff network, sort of research group. These things are popping up relatively frequently now across the United Kingdom. We have these things called So we have seen in the city, seen in HR, and I forget what the acronym stands for, but it's basically something about the reality of sex. So Jo tries to set up one of those sort of things, and she is subject to a campaign of sustained harassment and she's just made miserable at work. I think one of her employees, sorry, one of their employees calls her in one day and compares her to a racist Uncle Tom. Um, there's a letter signed by 300 members of staff saying that she's beyond the pale. There's, you know, she's put through the ringer. It has a devastating effect on her. Just so people can understand if they're not familiar with the case, Joe Phoenix is a very mild-mannered, very bookish, deeply respected, deeply respectable. You know, she's not a hothead. She doesn't scream and shout. She will sit down and discuss matters with people who disagree with her. She also happens to be a lesbian, and very, very often lesbians are the targets of what I disparagingly call the gender Borg sometimes, people on the other side. Anyway, the judgment in Phoenix is coruscating. It is extraordinary. Ordinarily, a tribunal tribunals are meant to sort of bring people together, and they're meant to be different to courts. They're meant to be a little less formal. They're meant to just get things dealt with and let everyone move on. This tribunal judgment is extraordinary because it sounds like a high court judgment. The tribunal judge goes out of his way, him and the lay members, to basically say, look, the staff at the OU, when they gave evidence in this tribunal, simply lied. Their evidence is rejected on key points. There was one member of OU staff who said, oh, Joe Phoenix said something that upset me and I had to go and have a cry or something. And the tribunal judge said, well, I've watched the evidence. There's nothing in there that would make anyone cry. I don't believe this person. And it's extraordinary because it wasn't just one member of staff. Professor after professor after professor after professor was found to have lied. It is an extraordinary judgment. It says that Phoenix was subject to sustained serious harassment, that you can't believe a word that her accusers say, and that their conduct to her was appalling. She was, in English legal terms, constructively dismissed. That is to say, her work conditions were made so appalling, she resigned. It reads to me like a judgment where aggravated damages, that is to say, damages which indicate the displeasure of the court at the conduct of the defendant university here and the lies of their witnesses. I think there is a very good chance of aggravated damages in this case. It was, I mean, to say it was a bad day in court for the OU just really understates matters. I've never read a judgment like it. And if you're, if you're, sometimes people quite enjoy these judgments. If people look, it's quite dramatic. This one, if you're interested in it, just Google it and have a read. It's I think it's about 300 paragraphs long, but I could tell your listeners it's a good read. It's a good read. So yeah, that's Bailey and Phoenix for you.
I've got my weekend reading all picked out.
Excellent.
So, what I'm getting, just to sort of back brief you, is that Forstater changed the landscape. We're still waiting to see whether Bailey can hold Stonewall responsible directly.
Yes.
But the Phoenix case is where sort of Stonewall thinking, not necessarily Stonewall itself, but academia, which is the most stonewalled of professions, basically showed its hiney.
Totally.
And got called out in court.
Yeah, so, and it's mentioned from time to time. Jo certainly mentioned it in her evidence. And the dark hand of Stonewall is always at play in these sort of workplace hostility type claims. They're never too far away from the villain of the piece. And as a direct result of the Phoenix case, I think it was, I was told last night that Stonewall now have a legal disclaimer on their workplace stuff that says, please do not rely on this. We are not providing legal advice, which anyone listening who knows anything about the law of exclusion clauses will recognize, one, that that's pretty desperate, and two, it might not save Stonewall's skin, that. But very interesting that they felt the need to do it. Each one of these cases further opens a flank in the enemy forces. So to mention another case, if I may, we had the case of Rachel Mead, who was a social worker who on her private Facebook made some relatively tame, by my standards, certainly, gender critical comments. She was a social worker of, I think, 20, 30 years standing, something like that. She was, you could predict where this is going. She was grassed up by one of her colleagues who said they felt unsafe and all the rest of it that they do in these things. Um, and the effect of the judgment in that case was again to broaden the jurisprudence, because the judgment in that case said, well, the people who reported her on her Facebook, you have to look at these people. And as a regulator, because the regulator here was Social Work England, we now say as a court, you have an additional duty to go and look at the people making these allegations. It also found that if you use a word like turf and that sort of thing, that is insulting. So every time one of these cases comes to court, the jurisprudence sort of unfolds a little bit further, and it's only unfolding in one direction, which is broadly speaking in favor of the gender critical side.
That is very interesting.
Mm.
It's of course not a guarantee, but it sounds like the direction of the thing is sort of going in our way, and it's of course courts being what they are, we can't count on anything. But
No.
it does sound like the landscape has altered to the point that perhaps Stonewall is a little bit afraid of what they've done.
Well, like, I mean, if they're sensible, yes. And you don't see them, they're quite quiet about these cases these days. So I told you about them failing to get permission to intervene in Forstater. When that happened and they found out the EHRC had got permission to intervene on Maya's side, they were quite noisy. And they were saying, I think they called it a kick in the teeth for gay people or something like that, which is a bit ridiculous. I find ridiculous as a gay person, having my sexuality and civil rights movement misused to persecute a woman. But the point I'm making is they used to be quite mouthy, and now they're very quiet about these cases. They have very little to say about these cases because they must know, mustn't they, that the workplace cultures that they fostered and adopted, and so much of what they say is based on a misstatement of the law, is being shown again and again and again to be a very clear litigation risk. And any sensible employer now looking at Stonewall in the United Kingdom, if you join their schemes, you're at grave risk, frankly, of an employee taking you to a tribunal, which is as it should be. I mean, I have to say, in the hurly-burly of the gender wars, particularly as a lawyer, it has been a point of pride for me to see good old British common law standing up against Stonewall bullying more often than not women at work. There are a few male cases around, but predominantly it's women getting the rough edge of this.
Right, right. It is somehow tending towards a sex-based outcome, almost like witch hunting,
Well,
almost like witch
quite,
hunting.
quite. Yes.
All right. So let me, since you have given such wonderful, fulsome answers, let me lay out some preliminary ideas for you about the states.
Yes, please
Uh,
do.
because and I'll provide you a map when I post this at the distance.
Great.
Um, you have to, of course, start with a patchwork view of the American states, because we have red states and blue states and purple states, right?
Yeah.
It's the famous color scheming that has solidified in the 21st century.
Yeah.
And as of right now, speaking to you right now, there are 23 states in the Union that
Yeah.
have Republican trifectas in government. That is, the Republican Party holds both the state House of Representatives and the state Senate in the legislature, as well as the governor's mansion.
Yeah.
So they have all the lawmaking abilities in 23 states. There are 17 states where Democrats have the trifecta.
Yeah.
And there are 10 where government is divided. One party has control of one or two out of the three, and the other party has control of one or two out of the three. It's a mixed bag.
Yeah.
So there you go. 23 Republican, 17 Democrat, 10 purple states. Which set of states do you think has been passing bans?
I,
Just
I,
as
I'd have to say that it would be the Republican ones, but are you about to tell me that's wrong?
well, no, actually, you're absolutely right. You're absolutely right up to this point.
Right.
And what 2024 is going to be about in America is changing that particular dynamic. And I'll explain as we go, but we can start in the red states, and you can start to see a pattern emerging. Um, if you start in Ohio,
Mm,
which is where many of my friends showed up to testify in the state Senate
yeah.
for the Saving Adolescents from Experimentation Act, which is a marvelous name. The
Rather
SAFE
apt.
Act.
Yeah, I like it. Yeah.
Yeah. We had Prisha Mosley, who is a wonderful detransitioner, testifying. Corinna Cohn, who is a calls himself a disappointed transsexual. He is half of the Heterodorks podcast with Nina
Oh
Paley.
yeah. Yeah, yeah, yeah. Yeah.
And then Jeanette Cooper, who is with Partners for Ethical Care, and Riley Gaines, and a
Yeah.
bunch of people all showing up to testify for this bill.
Mm,
So, in terms of legislation, you could not ask for a more grassroots approach to passing legislation. This is people showing up, and there was only one that I counted in the Senate hearing, Ohio Senate hearing that I clipped at the distance. There is only one person from a conservative organization.
yeah.
Despite everything you've heard about supposed right-wing bags of money that are funding the gender critical movement.
Oh, that old trope. Yeah.
Right. The fact is, there's only one conservative organization in America that has been consistently on our side with this, and that's the Alliance Defending Freedom. The
Right.
Heritage Society has been there as well, but ADF is the one showing up in the states.
Yeah.
ADF is the one showing up in courts. So, good on them. They're a conservative or even right-wing organization, but they're the only one.
Yeah.
And that's interesting because shouldn't we have, a ton of these right wingers
Be
showing up
nice.
to testify, And
Yeah.
instead we have someone like Jeanette Cooper. Jeanette Cooper, who said that she's a former Democrat. That's what she said to the Ohio Senate panel in the hearing. She said, "We let our kids wear what they want and cut their hair however they please. We
Yeah.
accept and love our children as lesbian or gay. We are liberal like me and conservative. We are atheist like me and religious. We are former Democrats like me and former Republicans. We are diverse."
Mm.
So it's a very powerful statement of just how this issue really shakes up the normal political partisan lines. And this has been confined to the red states so far, but it's going to spill over.
I do
Um,
hope so. I do hope so because, obviously we see, just from our point of view, we're not well versed in US politics, but we broadly know the difference between a Republican and a Democrat state, and we see sort of Republican states catching up. Although it's strange to see Republican governors occasionally veto the legislation as it comes through, which has happened on a few occasions. But it does make me, just to your point about will this spill over into the Democrat states? I mean, that seems unlikely to me. I can't imagine California ever passing a ban on this sort of thing. Or am I? Am I? I don't know though. Am I being ignorant there?
well, we're going to end up in California, and
Okay.
that's where it gets very interesting because the public opinion is not the same as the Democratic Party structure, right?
Oh, okay. Right.
So public opinion is on one side of this issue, and it's not quite the same as what Democrats are at. Half the Democratic Party in terms of the rank and file, people who would normally fall under the sort of assume this person, people that you would normally assume as Democrats, half
Yeah.
of them are not down with this. So
Right.
there is an exciting thing happening in California. There is a ballot initiative
Yeah.
that will skip the Democratic legislature.
Wow.
And that means that if we can get it on the ballot, if we can get enough signatures, and I say we, but Erin Friday is the woman who is doing the most work here. She is with Protect Kids California, and she has just been tirelessly gathering these ballot signatures. That's the chief hurdle. If we can get enough ballot signatures, then the likelihood is that the California voters are going to pass the ballot initiative and
Wow.
circumvent the state legislature. And if that happens, narratively things change. They have to change.
Yes.
Democrats cannot be on the wrong side of democracy like that for very long. They have to figure out how to close that dissonance, how to resolve it. But to your
Wow.
point about the Republican governors, that
Mm.
really just shows you actually how much of we are the grassroots movement and how we have been fighting against something that is entirely industrial. It's an industry, right?
Mm.
A gender industry. Mike DeWine, he is the governor of Ohio.
Yeah.
When he vetoed the bill, and his veto has been overridden,
Yeah.
um, he said that it was about protecting human life. He said that many parents have told me that their child would be dead today if they had not received the treatment they received from an Ohio children's hospital.
It's
So,
just absurd thing for any politician to say, and it's a complete misuse of suicide. We used to have guidelines against this sort of thing. We have a charity, you may have it in the US as well, Samaritans, who used to jump on people if they said that suicide was referable or explicable to one cause, because they said you've got to be very careful doing that because it's a very complex phenomenon. And also, suicide has a terrible habit, particularly in young people, of clustering. If you get a suicide in a school, statistically, chances of there being a second suicide are very, very high. And one of the terrible things that the gender Borg, as I call them, do is they weaponize suicide. So it's bad enough to hear that from a common or garden politician, but to hear a governor of a state say that, it's just unbelievably reckless and irresponsible.
yeah, exactly. And my point, of course, is that he had been lobbied very hard.
Of course.
The clinics, the clinicians, they lobbied him very hard. The parents who have done this to their children, who don't want to face up to the potential harm, the ones who have, rationalized all the cognitive dissonance away with this suicide threat,
Yeah.
they lobbied the governor and he vetoed it. So you have a very different group of people who are lobbying the governor. And this is happening again in New Hampshire. I don't know if you noticed there was a bill in
Yeah.
New Hampshire, House Bill
Yeah.
619, which would require, it says to require a person to attain the age of majority for genital gender reassignment surgery.
Yeah.
And I am been told this is a legislature that has Republicans in charge of both houses, but it was a slim majority. There are in the House 198 Republicans and 195 Democrats. There are three
Wow.
independents. There are
Wow.
actually four seats vacant right now. So it was very, very slender majority. And so it helped that 12 Democrats broke ranks.
Yes.
And you saw some of the Democrats abstain from voting on the bill. Some of them were absent.
Mm.
And one of them, a Representative Jonah Wheeler from Hillsborough County, said that this was a bridge too far. He said that these are
I
irreversible
think I watched
surgeries.
his speech. He's quite a young black man, isn't he? Have I got the right?
Yes,
Yeah, I
you're
watched his
thinking of.
speech on Twitter. I thought he was really impressive and very thoughtful, and he said very human and the sort of things I think any centre left-wing politician should be saying about this, because it shouldn't be left and right. Whether or not children are potentially mutilated by a hokey cult shouldn't be a question of, classic left-right arguments about, I don't know, state power or markets or wages or anything like that. It should just be a basic matter of humanity. And I thought his speech was extraordinarily effective and dignified. And of course, the reaction to it was sort of inversely symmetrical to that. It was just unhinged, and he was called every name under the sun on social media. But he must have known that was coming, and good on him for sticking to his guns. I thought a very impressive young man.
Yes, and that raises, the specter of these people who do vote, who do cross party lines. These Democrats are going to come up for primary challenges.
Right,
Um, there
right.
will be attempts to take them out, and it is going to be up to us who are still maybe inclined to vote for Democrats,
Yeah,
possibly. It's going to be up to us to figure out how to support these people so that they don't lose their offices as a result of these votes. It has
yeah.
to
Well,
be
you've
okay.
got to do that, otherwise they're just going to be purged.
Right. It's got to be okay to be a gender critical Democrat.
Right.
So there are two states that are worth talking about that have had two very different outcomes. They both passed a ban on pediatric sex trait modification, Alabama and Arkansas.
Yeah.
And they're two very different attorneys general. Steve Marshall, the Attorney General of Alabama, is sharp as a tack. I've been aware of him for his entire career, and I've been observing him even as opposition.
Yeah.
I have to say, he's a steel trap lawyer, and
Good.
you don't want to step into that trap because he will shut and you will be caught. Um,
I like him
I
already.
I do not know about Tim Griffin, who is
Hmm.
the Attorney General of Alabama, and he was a bit more hands off. He did not have a personal hand in the case. In these two cases, have, of course, two different names. The Alabama case is Boe v. Marshall,
Hmm.
BOE v. Marshall. And this is an 11th Circuit case. And the 11th Circuit has this long history with Alabama. So this is sort of a formula that the gender board thought that they had, that they could use, which is where Alabama will pass a law, and then the 11th Circuit will issue a preliminary injunction,
Yeah.
whereupon, Alabama will argue a case. The 11th Circuit will say, no, you can't do that, and slap Alabama down. And ACLU lawyers will bill the state of Alabama for hundreds of thousands of dollars.
Yeah.
That's how it normally goes. And it didn't work out that way this time.
Yes.
Because what happened is that the plaintiffs in this case, suing to overturn the state law,
Hmm.
what they did was they pointed to WPATH as their gold standard, right?
Yes.
And also, they're citing the American Association of Pediatrics and the Endocrine Society. But both of these organizations are signposting WPATH, right?
Yeah.
Everything's leading back to WPATH. So what happened is that Marshall requested discovery on internal documents
Yes.
from WPATH, and after there was a bunch of negotiation where the other two organizations said, "Well, really, you should be talking to WPATH. We're not really the experts on this. You have to look at WPATH." And ultimately, what happened is WPATH had to provide the information behind their standards of care, right? WPATH.
Those would be the standards of care that removed all lower age qualifications for surgery recently, and said that children could be eunuchs, and which Genevieve Gluck at the Redux publication has plausibly connected to some very dubious characters who write all sorts of things on the internet about eunuch children. That's who we're talking about. Yeah.
That is who we're talking about. That WPATH,
Yeah.
formerly the Harry Benjamin Foundation.
Yes.
But they decided not to be named for a quack anymore and renamed themselves WPATH to sound really professional.
Mm.
Put the word professional in the name of the organization, and people will act like we're professionals.
They always
Uh,
fly too close to the sun, these gender Borg. They're very like Icarus. The ACLU is all over Twitter talking about how wonderful WPATH is and that sort of thing. And I have to say, as a lawyer, it warms my cold black heart when they embroil themselves in litigation because I raise an eyebrow and say, you're going to open yourself up to disclosure, or what you Americans call discovery. And of course, that is precisely what's happened here, isn't it?
And that is precisely what happened. And Alabama claimed that the
Mm.
WPATH standards were shaped by ideology rather than evidence. And the
Yeah.
11th Circuit agreed. The 11th
Yes,
Circuit let the bill stand.
they did.
So
I think we were lucky on the 11th Circuit. I think it was a 2-1 majority. And I think it partly came down to the composition, as it always does, luck of the draw of what judges you get. But I'm pretty sure that was the case that Korodansky for her women's rights group and friends put in very impressive submission, which pointed out to the court, look, if these guys are right, why is everyone in Europe dropping all of this? And it was really clever collecting globally the information, which the court then referred to, and the judgment you're referring to is extremely well written. I mean, American jurisprudence, when your judges are firing on all cylinders, it's something else. It is, and I've obviously read this judgment. It conducts a sort of global survey, and it's actually a really useful resource because the lead judge goes through what is happening in all the other countries on this, and comes to precisely the conclusions that you've described.
so in Alabama, you
Yeah.
have one case that has been a success, and then in Arkansas, you have a case that was not a success. And there has been a pretty good post-mortem that I will point you to, and I will link to when I post this
Great.
to the distance.
Mm.
It is written by someone named Unyielding Bicycle. That's the only name I have for this
Great
person. But
name.
but this person is an anonymous legal professional uh,
Okay. Yeah.
who writes at the LGBT Courage Coalition,
Oh,
which
okay. Yeah. I've just clocked them today. They look very interesting. So yeah, this sounds good.
yes, they're a startup organization. One of the most important members who you will be familiar with is Jamie Reed.
Yeah. 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 She's very impressive. Yeah. Yeah.
Very impressive in person, let me tell you.
I can
Um,
imagine. Yeah.
so you have in Arkansas an example of what not to do. Brandt
Right.
v. Rutledge is the name of the case.
Uh-huh.
Brandt v. Rutledge, and because there's a record, it is, shall we say, legal canon, just like the 11th Circuit case we were just talking about.
Yeah.
So who knows? Because American jurisprudence is infamous for just being a total wood chipper on the way up to the Supreme Court.
Well,
Who
quite. Yeah.
knows?
Yeah. That's a great way of
Who even
describing it.
who even knows how these cases will shake out eventually in the Supreme Court? But when these cases eventually wend their way to the Supreme Court, here are fact patterns established in federal courts. And in the
Yeah.
Arkansas case, it's interesting what they did not argue.
Yeah.
They never argued that trans children should be permitted to medicalize young in order to disguise their sex later in life. They argued that trans kids need to medicalize young for the sake of short-term mental health. Again, they're going for the suicide threat.
Yeah.
And again, what happened here is that Arkansas had opportunities to capitalize on admissions in the case. There were witnesses for the plaintiffs who made admissions about gay conversion, about the possibility that gay children would be identified as trans.
This just
Uh,
makes me so angry, Matt. Like, how do you make that admission in court? And a judge goes, "Oh, well, that's all right then." So, sorry to cut across you, but I'm just, find that jaw-dropping that a plaintiff can come to court and say, "Oh, yeah, well, we might just be conducting, modern day gay conversion therapy," and the 11th Circuit says, "Oh, okay." I mean, that's extraordinary, isn't it?
this was not the 11th Circuit. This was
Oh,
the
sorry,
sixth, I believe. I don't remember
six.
which circuit it is.
Okay,
um, Out
yeah,
there in Arkansas.
right,
But basically, the plaintiffs made admissions that if someone had pressed them, right? It's not like they said, "Oh yeah, we're doing gay conversion therapy." They made admissions about what kind of children fall into this category. That
yeah,
if someone informed had followed up in the cross-examination,
sure.
there would have been serious damage. The judge, who is apparently a Democrat appointee and probably leans Democrat, might have come away with a different impression of things had somebody argued on behalf of the gay kids.
Well, quite, I mean, you can't. This is the thing, isn't it? You can't always blame the judges. All of our common law systems depend on cases being argued properly. I'm not familiar with this case, so maybe I shouldn't be too critical, but that does seem to me a rather obvious deficit.
Yes, so it was not the best argumentation, and so this particular case, is lost at that federal court level. So who
I see.
knows how it will play out in time?
Well,
But the
quite.
fact is that we've already got all of this information that is already on the record, that is already part of the record. Who knows whether it will matter in the end? But that's how
Yeah.
it's shaking out in the courts.
And we've sort of got a boiling pot here because I think one of the things we're waiting for over in Europe is we are waiting for one of these conflicts of circuit appeal, federal court. We're waiting for one of these to end up on the Supreme Court docket. I mean, obviously, you're over there in the States. Do you have any idea when this might possibly end up in your ferociously conservative Supreme Court that will probably sort this out, I would have thought?
Well, it could be any time. Unfortunately,
Right,
there's no pacing it with the
right.
Supreme Court. It might be next year. It might be years from now. It
Yeah,
depends on how quickly the federal courts move on these issues. And
yeah,
remember that all the time that this is happening, the politics are changing.
right.
That's one aspect of it, is that we're grinding it out in courts while the culture at large is shifting on this.
I
Um,
suppose that jurisprudentially, we also have a Supreme Court with Alito and pals reversing Roe v. Wade that is very much in favor of saying to states, you do what you want in your particular state. So perhaps it would be unwise to assume that any, dispute would be resolved in favor of the gender critical side. What one could easily have, I suppose, in theory, a conservative Supreme Court saying, well, if a state wants to go wacko on gender ideology, that's a matter for that state. That would be consistent with the jurisprudential trend up to this point.
yes, you're getting it exactly right. The Supreme Court, there's no guarantee what
Yeah,
they're going to decide. All we
yeah,
know is that the cases are starting to take a shape at the bottom, and they're going to filter up to the top, and who knows what the court will be like and which cases they will decide and how, um,
yeah.
and on what basis. Because the Supreme Court is mercurial this way. The
Well,
Supreme
quite.
Court
Yeah,
can decide that, everything you people have been fighting about is pointless. We're going to make the decision on this basis.
yeah.
That has nothing to do with anybody's argumentation. They've done that before.
Oh, sure. Yeah,
So we have now, I guess, an appreciation of the red states.
yeah.
So let me go ahead and tell you something about Maine. You may have seen there was an attempt in Maine to pass legislation to make it a sanctuary state.
Oh, yes, 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 yes. Yeah.
Right. And that didn't go over. It died in committee. It got
Oh, did
zero
it?
votes in committee, is my
Oh, I'm pleased to
understanding.
hear that. Good, good.
Uh, and for the same reason that the governor of California, Gavin Newsom,
Mm,
vetoed the bill to make California a sanctuary state.
yeah.
So what explains all these sanctuary bill efforts, of course, is that we are having this success. So you see in two states that have a Democratic trifecta, Maine
Mm,
and California, you see these sort of corresponding efforts, but they're flailing. They're not working because they're unworkable.
okay.
Uh, so so in that environment, we have this California ballot initiative. Now, I cannot speak enough or highly enough about Aaron Friday and Protect Kids California and what they're doing. As I mentioned, this is a ballot initiative, and you should understand that California has always been a bellwether in terms of direct democracy.
Yeah.
That, for example, in 1978, there was a Proposition 13 that if you were looking from 20,000 feet, you would say, oh, that looks like it might be big in America. It was an anti-tax proposition. Um, the
Okay.
uh, the residents of California were tired of paying tremendous property taxes. So it was
Yeah.
this anti-tax rebellion. It was passed um, without the participation of any state leaders. It was the grassroots effort. And that anti-tax sentiment is one of the electoral forces that Ronald Reagan, who had been governor of California,
Of course.
right,
Yes.
just
Yes.
just
Yes.
before this,
Yeah.
he rode that particular wave to the White House in 1980.
Yes.
So California has been a bellwether this way. What we
Mm.
want to do is ring the bellwether this year. If we can get 500,000 signatures approved and recognized by the state, we can have uh, a ballot initiative passed by more than 70%, is what the polls tell us. More than 70%
Wow.
of Californians will vote for this. They will
D-
vote
d-
to end pediatric transition. They will vote to end schools transitioning children in secret.
wow. Does Erin think that she's going to make those numbers?
I have not been able to talk to Erin in the last week or so. She
Okay.
seems confident. The
Good.
people who are out there in California are they're taking forms with them everywhere they go. They are talking to every single person they meet. They Erin
Good.
was telling me or telling a room of people recently about how she carries them in her purse, the forms, and she'll meet, an Uber driver
Yeah.
and she'll start talking to the Uber driver, and the Uber driver will be, "Oh yeah, of course we can't do that to the kids." And she'll say, "Well, here, why don't can you sign this petition for
I
me?"
I
And
I sort of recognize this because once you stick your head into gender, it becomes a bit of an obsession. Even if you, because once you see this stuff, one cannot unsee it. So I relate to that, and I must confess a bit of jealousy for the American system because we don't have ballot initiatives at all. We're staring down the barrel probably of a new government, which is likely to be a centre-left government in the UK, which is quite unpredictable. It's got a cautious leadership, but they're making all the wrong noises on gender. My suspicion is that we'll be okay and they'll actually screw over their gender supporters. But we don't have a similar mechanism as you do, either to override at either a state or a national legislature. So I must confess some envy.
well, we decided to have an American experiment, and part of that involved breaking up with you Brits
Yeah, yeah, yeah. Quite, quite.
for a couple hundred years.
Yeah.
Um, one of
But
our
here we are. Here
experiments,
we are on a podcast, though. So it wasn't a permanent and final
not a
break.
permanent separation.
No,
Um,
no, thank you.
so I hope that that has given you some a better idea of the
It
map
has.
of the problem in the U.S.
It has.
Um,
It's quite hard as a Brit, I have to say, sometimes just to grapple with the sheer scale of the size of your country, because we sort of get snapshots, and obviously we're not as versed in, your constitutional arrangements, so it's quite difficult as a Brit to keep up with exactly what's going on in America. So that's been really valuable. Thank you very much indeed, sir.
I appreciate that. And
Yeah.
have you got anything else you can tell us about? You had been talking about those cases, and you mentioned Rachel Mead.
Yeah.
But there's a Dr. Almut Gadau. I'm not sure how you pronounce that name.
I'm not familiar with
Um,
that case, I'm afraid. I have to
um,
apologize. That's not a case I know about.
or you had cited one more case. That's fine. We don't have to
Might be
talk about it.
Shahar Ali is the next
Shahar
case
Ali. Okay, yeah. Go
we're
ahead and tell
waiting
us
for.
about Shahar Ali.
Oh, that's going to be a very interesting one. We're getting judgment in that on the 9th of February, so the same day as a big debate in the House of Lords on one of these conversion therapy bans. It's going to be a very big day in gender wars. And Shahar Ali is a really nice bloke. He was deputy leader at one point of the Green Party in the UK. The Green Party isn't much of a force in the UK. They've only got one MP, but they're a little bit more significant locally. And, they contribute to the national debate. So it's not as if they're irrelevant. Shahar is well, just firmly, he's a realist. He lives in reality. He doesn't believe in magical gender souls. I hesitate sometimes to say, "Oh, he's gender critical," as if because it almost sounds disparaging. Um, but Shah has taken the Green Party to court because they expelled him for gender critical beliefs. And this is going to be a really interesting judgment on the 9th because we know from Mead, Bailey, Forstater, Phoenix, Denise Farney with the Arts Council was another case. We've got a legion of cases in an employment context. We now have an Equality Act claim in a non-employment context. Although I say that, I suspect Shah probably did draw some sort of salary, or at least would have had expenses as deputy leader. But in any event, the context is quite different. The court will now be invited to pronounce on whether expelling someone from a political party because they have gender critical beliefs is lawful or not. And I'm really interested in this case because just putting all my personal opinions to one side, and I should emphasize, I am a humble criminal lawyer. I am not an Equalities Act lawyer at all. I've sort of learnt this by osmosis by sticking my head in this debate. But just logically speaking, I would have thought that a political party has a greater margin of appreciation to say, actually, we're fully on board with gender ideology. I mean, that must be right that a political party could, in theory, do that, even if I disagree with them. And certainly if that was, I don't know, a manifesto commitment or something, if someone starts speaking out against the party, I could understand why a party might be able to do that. Now, I don't think it's quite as clear as that in the Green Party. I don't think it was a manifesto commitment. I think it was more of a grey area of adopted policy. So I don't envy the court on this, I have to say. The court is going to pass a judgment on what political parties can and cannot do in terms of this gender debate. Now, if it goes against us on the sex realist side, for the reasons that I've expressed and the reasoning I've set out up to this point, I won't be too upset because I do think political parties are different animals to employers. But if it goes in our favor, I think that will be really very interesting. Really very interesting. I mean, it will be one of those judgments where one had to study in granular detail. Well, are we talking the difference between a sort of pledge, a policy commitment, a manifesto? Are we talking something akin to workplace bullying? It's going to be a judgment where one has to look at the detail. But if Shahar wins, this will have enormous implications for the way that other MPs have been treated. And I'm thinking principally about the Labour MP. Labour are Democrats, so the main opposition in the United Kingdom at the moment. And there's a particular MP, Rosie Duffield, who's the only Labour MP in a county called Kent. She's gender critical and has been pilloried. She's always, the LGBT, WTF, lol idiots are always calling for her to be expelled and lose the whip and so on. But if Shahar wins, that behavior against Rosie has to stop overnight. So it'll have enormous implications for the conduct of political discourse, because so much of the conduct of political discourse can be skewed one way or the other by these sort of cancellation type attempts, principally on social media. It's not unusual if Rosie puts a foot wrong for the next 2 days, everyone to be tweeting, either I stand with Rosie Duffield or her antagonists, the opposite. So that I think is going to be a highly significant case. I will mention one other, if I may. We're awaiting final submissions in a case up in Scotland, where Naomi Cunningham has been playing something of a blinder, representing a woman who was sacked from a rape shelter. And the rape shelter is run by a trans-identified male, so bloke, basically, doesn't have a gender recognition certificate or anything like that. And it is a case in which it is fair to say there has been some extraordinary detail about what happens when gender ideology infects a service, because we've had witnesses for the rape shelter saying things like, when women come in and say, I only want a woman, well, the quotes from the bloke that runs this are not pleasant, but I think they tell the story. At one point, he said in public, even bigots get raped. He also said people like that need to, quote, reframe their trauma. So he's talking about raped women who are asking, I think, reasonably for single-sex services. That will be a very interesting judgment too. So those are the two that we've got on the horizon. One, a political party, one, a single-sex space in the form of a rape shelter. And I can't think of a more acute single-sex space than that, frankly. So lots to look forward to, both in terms of law and the political development of this debate.
Well, that's very helpful. Thank you.
No
It
worries.
does sound like there has been a profound shift in
Yeah.
just the last couple of years.
Oh,
And
God, yeah.
so it is really good to hear that description. Um,
Yeah.
it has been a really great time talking to you, Dennis.
Hey,
I
you
really
too, mate.
appreciate your doing this with me.
Not at
Maybe
all.
we should do this again sometime. And
Sure.
maybe we can invite Eva and she can talk to us about Alberta and Canada.
Oh, that'd be great. I'd love to get an on the ground view of that. I read Eva's article on Distance Mag, your Substack, about the Premier's decision recently, and she's really plugged into this and is eminently sensible, and is, of course, as we know, Canada's preeminent lesbian, which which but one of her comments was reported recently in the British Daily Mail, and it obviously amused the journalist who said Eva Krylova, who describes herself as Canada's preeminent lesbian. I thought, I know that woman. So yeah, I'd love to do that.
Well, I'll see if we can make it happen.